Huettemann.
Huettemann.
Happens all the time, don't worry.
Thank you. Please.
Good afternoon, Your Honors, and may it please the Court. Everyone now agrees that this appeal is moot. The only remaining question, then, is what this Court should do with the underlying expired injunction order. This Court should vacate that order pursuant to this Court's precedent and simple principles of fairness. Start with the basic idea that it's not the state's job to keep an injunction against it alive. That's especially so here, where the underlying order expires by operation of law through the PLRA and through no fault of the state. Under the PLRA, the state is not required to do anything to prevent that automatic expiration, so the state should not be bound by an expired order it can no longer challenge on appeal. That was this Court's holding in Smith v. Edwards and Yates v. Collier, and those holdings decide this case. I'll turn first to Smith v. Edwards, this Court's decision from 2023. Now, Smith had almost identical procedural history as that at issue here. We had a district court issue a preliminary injunction in the plaintiff's favor based on plaintiff's claim that the Office of Justice was violating their constitutional rights. That injunction then expired by operation of law under the PLRA 90 days after its issuance. And so this court then dismissed the pending appeal as moot. After so dismissing, it turned to the question of what to do with that underlying expired injunction. Now, the panel first acknowledged that vacatur is an extraordinary equitable remedy, but that the initial principal consideration is whether the party seeking relief from judgment, here the state, caused the mootness of the appeal by their own voluntary action. Now, in analyzing that consideration and answering that question, this court relied heavily on its earlier decision in Staley and on the Supreme Court's decision in Banc Courtroom, both of which enunciated the rules for vacatur when an appeal becomes moot while it's pending. Now, in rejecting the previously long-standing general rule of automatic vacatur for moot appeals, the U.S. Supreme Court in Banc Court left in place the rule that, in a case like this, vacatur must be granted where mootness results from the unilateral action of the party who prevailed in the lower court. Smith cited that exact rule, Banc Court at page 23 and Staley at page 310, as the basis for its decision. And the Smith court went on to elaborate on how that general rule applied in the PLRA context specifically. The court said that though the defendants had complied with the preliminary injunction, they did not cause mootness by their voluntary action. And though the injunction automatically expired under the PLRA, and this part is key, plaintiffs could have sought an extension to extend its duration. That placement of the burden onto the plaintiffs here comes from the PLRA itself. In other words, the defendants had no duty to carry on that injunction in any way. That duty would lie instead with the plaintiffs, and so it is the plaintiff's lack of action that matters for the vacatur analysis. And so this court concluded in Smith, again quoting Staley, having been frustrated by the vagaries of circumstance, defendants ought not in fairness be forced to acquiesce in the judgment, and so the equitable result was vacatur of the expired injunction. Now, Smith's holding applies with equal force here. We have an injunction that expired under the PLRA's automatic 90-day period. We have plaintiffs who made no attempt to make that injunction order final or extend it in any way to preclude expiration. And so we have defendants who cannot be faulted for plaintiffs' lack of action, and so the proper recourse is to vacate the order. This court came to the same exact conclusion in Yates v. Collier, an earlier case. We have the same situation where the court found that the appeal was moot because the underlying injunction order expired 90 days after its issuance. And so, again, this court, quoting Staley at page 310, said that vacatur must be granted where the mootness results from the action of the prevailing party. And this court said in unequivocal terms in Yates that the appeal was moot because the prisoners allowed their preliminary injunction to expire. That's exactly the case here, and so this panel should do exactly what it did in Smith and in Yates and vacate the July 2nd injunction.
Counsel, what is the nature of the litigation that is ongoing in the district court?
Sure, Your Honor. So the plaintiffs have filed a second application for TRO and preliminary injunctive relief. I believe that was filed on March 26th, and it's now fully briefed. The district court then, just this past week, held a multi-day class certification hearing. It ordered post-hearing briefing, but it's yet to issue any ruling, at least as of this point to my knowledge.
So the class is not yet certified?
I don't believe so. That hearing was just held last week, and I don't think the district court has decided it yet because it ordered post-hearing briefing.
And what is the nature of the preliminary injunction briefing? Are we talking about the same 5 alleged violations of the Eighth Amendment? Or
You mean the exact same 5 that were in the July 2nd injunction? It's actually our position, Judge Oldham, in the lower court that the second application for relief essentially mirrors the first application for relief. There are some differences based on the steps at compliance that the state has taken since July, but they do directly reference the August 15th order from the district court, which contained instructions for how the state was to comply with parts 1 and 2 of the July 2nd order, which were the unstayed portions following this court's stay order.
did the state comply? I guess there was a stay issued by our court.
Correct.
Of 3 of them. There were things like develop a policy or something. So I gathered that those policies were never developed.
Not necessarily, Your Honor. So part 3 of the July 2nd order had to do with the heat pathology medications list. The reason that this court gave for staying that portion was because it was overbroad. It seemed to apply beyond LSP. But this state has since taken efforts to edit that medication list based on plaintiff's complaints in the earlier parts of that litigation. So there have been changes that touch on those stayed portions of the order, but again, they were stayed by this court.
But the long and short of it is that the gist of what's going on in the district court this summer is substantial, in your view anyway, substantially the same as last summer.
I agree with that completely, Your Honor. And I'll touch briefly before I give up my time until rebuttal on plaintiff's claim for why they didn't seek an extension of the preliminary injunction before it expired on September 30th. They said that it would make no sense for them to attempt any sort of extension because their concerns for higher temperatures were abated after September 30th. From an initial standpoint, I think this court made clear in Smith and in Yates that whatever plaintiff's reasoning for not seeking that extension, it's the fact that they could have sought an extension or made that relief final but did not do so that matter for the vacatur analysis. But on the merits of their argument there, on the one hand, if they're right about those abated temperature concerns, that would only reinforce this court's point in Smith that it's completely out of the state's hands. It's just as unfair to be held in limbo by this natural changing of the seasons as it is by the plaintiff's litigation decisions. But on the other hand, plaintiffs are actually incorrect about those temperature concerns, and I can point you to 2 things. First, the record in the district court shows that for approximately 40 days after this original injunction expired on September 30th, that the 88-degree benchmark, which was used throughout this litigation as when the heat concerns seem to have risen, that was exceeded. And you can see that in plaintiff status reports, which we cite on pages 7 and 8 of our reply brief. And the second thing I'll point you to is in that second application for preliminary injunctive relief that plaintiffs have filed, which you can find at ECF 201 in the district court's record, plaintiffs directly refute that position that they've made here. On page 5 and 6, the plaintiffs state that it is obvious and well known that the heat index can and often does exceed 88 degrees Fahrenheit before May and after October. And they go on to say that there is no scientific or medical basis to apply LSB's procedure based on the calendar rather than on environmental conditions. So plaintiff's own argument, own position, directly refutes their point in front of this court that it would have been futile for them to attempt any sort of extension. And so none of plaintiff's arguments distinguish Smith and Yates' holding from the case at hand here. So based on those precedents, this court should vacate the July 2nd injunction. And unless your honors have any further questions, I'm happy to take my seat until rebuttal.
Very good. You saved time for rebuttal. We will hear next from Ms. Stapleton.
Thank you, Your Honor, and may it please the court, Anna Stapleton of Paul Weiss on behalf of Voice of the Experienced and the individual plaintiffs here. I'm joined at council table by my co-counsel Samantha Pershaw of the Promise of Justice Initiative. Your Honor, as we've heard, the parties here agree on very much. We agree that the preliminary injunction that gave rise to this appeal is moot. This court accordingly lacks jurisdiction to review its merits. The only question is whether, as the en banc court put it in Staley, the state has satisfied its burden of showing an equitable entitlement to the extraordinary remedy of vacatur, and it has not. Contrary to my friend's portrayal, this is a classic case in which the party seeking relief caused mootness by its unilateral and voluntary actions. Unlike in Smith, the state defendants here twice sought extensions of the briefing schedule on this appeal, with the result that the appeal became moot, the preliminary injunction became moot, before this court had the opportunity to review.
Do you think that the state needed to take some extraordinary step, like moving to stay the injunction or preserve the status quo with the injunction so that it could be effectively Munsingware vacated later?
Your Honor, it's not just my position, it's, I think, the position of this court in Smith, that a party that is aware of impending mootness has an obligation to inform the court. This court in Smith rejected the idea that there was an available exception to mootness under the theory that it was capable of repetition yet evading review. And it did so by saying that out of the gate, excuse me, that argument failed because it did not evade review. 90 days, this court said, is sufficient time to review a preliminary injunction on the merits. I would also point out that the state defendants, of course, did immediately seek a stay and obtained a partial stay. And so in that sense, received some review of the district court's decision. But it is our bottom line contention that it is the party seeking relief from the lower court's decision, as the Supreme Court said in Banc Courtroom and this court said in Staley, that bears the burden of demonstrating entitlement to that relief.
What I don't understand, so obviously they sought a stay. Imagine they'd gotten a stay of all 5 of the provisions of the injunction. The injunction still would have become moot, right? It would still have disappeared. So
That's true, Your Honor.
I don't understand what they could have done. I mean, there are cases from all over the United States, I'm sure in preparation for today, you've read them, that say that periods up to 2 years are too short for a full appellate review. We might be able to review an injunction in 90 days, although I will confess to you I can't think of an example of our court having done that. But like certainly you wouldn't be able to complete the appellate review. You wouldn't be able to go to the Supreme Court and get, I mean, heck, you couldn't file a cert petition in 90 days generally. So I don't really understand how 90 days would have been sufficient under any set of circumstances to get final review of a preliminary injunction.
So first of all, Your Honor, I have one example for you. It's Barbie v. Collier.
I'm sorry.
2022. Forgive me, Barbie v. Collier. It's a 2022 decision of this court, and it did vacate a preliminary injunction, I believe, 8 days after it had issued. But to the court's broader question, look, it comes down to an issue of the equitable nature of the relief being sought, the fact that the party seeking that relief bears the burden. And the question is, were they denied the opportunity for review by their own conduct or by the vagaries of circumstance? Here, there is no question that their own conduct is what prevented at least this court from completing review prior to that 90-day expiration date. The question as to what would happen if they were seeking review by the Supreme Court, arguably harder, but it's of course not the one presented to the court here.
So I understand, I mean, Barbie's interesting, obviously a stay of execution. I suppose that those are examples. Now, if you include those, like a stay of execution, I can't think of other examples. In fact, I think I might have been on one in the last month or two. So those are obvious, right? Because there's a very clear emergency. They have to be done very quickly. They can't be delayed for obvious reasons. Can you think of an example in the PLRA context?
I don't have another example in the PLRA context, Your Honor.
Yeah, it's just really difficult to imagine a case outside of the extraordinary circumstances of life and death that we would be able to do it in 90 days, even if they had moved to expedite. I mean, we grant expedited briefing with some regularity, but even expediting briefing, it's hard to get a case briefed in 45 days.
I certainly understand the challenge, Your Honor, but I want to emphasize that it was the court in Smith, not just me, that said these are not categorically evading review, right? I would also emphasize the role that public interest has to play in this equitable analysis. So to the possibility that the court's concern is about sort of an unreviewed decision of the district court remaining on the books, I would point out that, first of all, the Supreme Court said in Banc Courtroom, and this court echoed in Staley, that those decisions are presumptively valid, right? And it is completely ordinary for decisions of lower courts to remain on the books without having received appellate review. And of course, in this circumstance, sort of the public has the benefit of both the district court's decision and the review by the motions panel of this court, which of course upheld many parts of the district court's decision. I would say that the opposite rule is more problematic. The idea that because of the 90-day rule imposed by Congress, paired with sort of the ordinary course of review in the courts of appeals, that most PLRA injunctions would end up being vacated anytime the state chose to notice an appeal, but then for whatever reason didn't complete that appeal, that the public would be deprived of all of those decisions almost by default is a much more troubling rule.
Well, a couple questions about it. Number one, that seems to be the rule that Congress gave us, right? There's no other, as far as I know, I can't think of another injunction or another provision anywhere in federal law that makes injunctions expire as a matter of law, as a matter of statutory positive law in 90 days. But that's the rule that Congress gave us, and obviously we're not at liberty to change it. And number two, you have unilateral control over this, right? You could have moved. You knew about the 90 days as well as anybody, right? And you could absolutely, under the PLRA, move and say, please make it final. Because God knows there's going to be another summer, and as your friend on the other side says, in the state of Louisiana, not unlike the state of Texas, we have summer that extends well past September 30th. So the sort of finger pointing in this case is odd, right? Because you have complete power to do it just as much as they do. And perhaps more, I guess.
Your Honor, I would take those 2 points separately. So first, yes, Congress creates this 90-day expiration rule, but it's not a vacatur rule, right? The preliminary injunction comes to an end, but it's not a rule that the decision is automatically wiped off the books. And second, this question about extension. So certainly the statute provides the opportunity for plaintiffs to seek extension. It's not our unilateral decision insofar as, of course, the district court would have had to have granted an extension, right?
But you could have asked for it.
We didn't in this circumstance, but I also want to say a little bit about both the sort of importance of that decision and why it was made here. So first, Smith does not say that there's some kind of affirmative burden on plaintiffs under the PLRA to seek an extension in order to avoid mootness. What it says is when the state has sought an appeal, when the state is arguing that the preliminary injunction is not moot or should be considered anyway under the exception, and the plaintiffs have not sought an extension, that combination of circumstances amounts to the vagaries of circumstance, which under Banc Corp and Munsingware say that vacatur is appropriate. Here we have a different circumstance. It's not just the fact that we didn't seek an extension. It's also the fact that the state defendants here themselves chose to extend the briefing schedule, right? And it is, I take Your Honor's point that, we had litigation choices to make, but in Banc Corp, the Supreme Court makes absolutely clear it is the litigation choices of the party seeking relief that is relevant when the question, that is relevant to the question of who is at fault, right? In that case, of course, the court was considering a circumstance in which there's a settlement, which obviously requires agreement by both sides, action by both sides. But it was the party that settled and wanted vacatur, for which the Supreme Court said, well, no, you would have otherwise had an opportunity for review. You chose to give up that opportunity. You made a litigation choice to settle. You do not also get the benefit of vacatur.
And so your point is that by seeking an extension, that's the functional equivalent of settling?
I would say so, Your Honor. It's a litigation choice, and one in this circumstance made against the knowledge of the 90-day expiration.
But your decision not to seek confirmation is not the functional equivalent of settling?
No, Your Honor. I would not say that it's not a litigation choice. It absolutely is, right? And we made that choice primarily because we knew at the time that the district court was seeking, the district court was preparing to hold a bench trial on permanent injunctive relief, right? And it would have likely delayed that trial to pursue an extension of what was preliminary relief.
It's very interesting to me because I don't see the distinction in the PLRA. There's nothing about extensions. There's just a provision that says if you don't want the 90-day expiration, you have to seek confirmation. That is, you have to turn that into a permanent injunction. I don't see a distinction between what would be effectively a bench trial leading to a permanent injunction versus the extension of a preliminary injunction. In fact, it seems to suggest there is no such thing as a quote-unquote extension of a preliminary injunction.
Let me say first, Your Honor, that the court does not have to reach a decision on that issue in order to decide this case. Again, the main question here is the litigation decisions made by the parties seeking relief, and the decisions they made were to allow this case to become moot before this court could review it. Secondly, to the extent that you are looking for a substantive answer, I think Smith has that answer. In this circuit, Smith has said extension is available, and to the extent that you have questions about interpretation of the statute, I would say the statute does not say that the order has to become a permanent injunction. What it says is that the order must become final. And no court that I'm aware of outside of the 11th Circuit has said that that statutory language is properly interpreted as a requirement to make the injunctive relief permanent.
What would be I don't mean to split hairs here, but extending a preliminary injunction is the opposite of final, right? It's still preliminary. That's by definition not final.
So the question is the finality.
Final injunction by definition is a permanent injunction. What possible distinction is there?
I disagree with that, Your Honor. Final order, I believe, is the language of the statute, and what the statute requires the court to do is to confirm that its preliminary relief comports with the sort of substantive requirements of the statutory provision.
And hence is final.
And then is a final order on the preliminary injunction. But again, Your Honor, we don't think this court needs at all to reach this issue. It's not squarely presented by the question of vacatur, right? Smith gives us what is currently the rule in this circuit, that extension is available, or at least presumes that extension is available. And on the backdrop of that extension, taking into account the totality of the circumstances, as it is an equitable decision, what stands out here, and the key deciding point, is the litigation decisions made by the parties seeking relief. They chose to extend their briefing schedule, and in so doing, allowed this appeal to become moot.
Are you familiar with the litigation in the district court? Like the ongoing litigation?
To an extent, Your Honor, yes.
What is your understanding of the requested injunctive relief for this coming summer of 2025?
It differs substantially, and on this point we do disagree with our friends on the other side. It differs in a long list of ways. My co-counsel who handled the hearing last week provided me with, I think, like a 15-page list of differences. But the two that I would emphasize, Your Honor, number one, we do seek to remove the current limitation in the policy that makes the heat policy in effect only from May through October. And you heard some of our arguments to that point from my friend. So that is much broader relief than what was granted in the first preliminary injunction. Additionally, we put forward a list of specific medications that we would have added to the heat pathologies list. And again, just another example of the ways in which the relief that we currently seek is broader than what was considered by the district court in the first preliminary injunction.
And I'm sorry, did you say equipment policies? Is that the second prong?
I'm sorry, I didn't quite hear you.
Yeah, the audio here is terrible. You said that you sought significantly broader, and I thought you said equipment policies. Is that the second?
No, Your Honor, medications.
Medication policies.
Yes.
So are you satisfied with the equipment policies? This is the second prong of the injunction.
Are we satisfied that the equipment policies were put into effect? I believe the answer on that is no. So it's our view that no part of the initial preliminary injunction was ever fully complied with, including prong 2, as you say, which was the requirement for additional equipment.
And this is all sounding in the Eighth Amendment, right?
Yes, Your Honor.
So is there authority that I'm unaware of about how the Eighth Amendment requires sunscreen?
Your Honor, let me say once more that this court does not have jurisdiction to reach the merits of the preliminary injunction. I am not well versed on the specific question of sunscreen. What I would say is that what the district court found quite clearly was a disregard for the threats presented by heat and a need to provide protective equipment inclusive of sunscreen.
And is there a place, you can't tell me today where I would go to find what the Constitution says about that?
Your Honor, I'm quite confident that the Constitution does not mention sunscreen, but of course...
I would include like judicial glosses on the Constitution. I don't mean to be overly formalistic about it. It's surprising when you see a PLRA injunction that has things like specific references to exact temperatures, the National Weather Service, sunscreen requirements.
I will say one more time, Your Honor, that the merits are not on review today. And
Counsel, I hear you, and I understand it, although obviously the fact that you all agree about mootness doesn't mean that the merits aren't before us, right? It means that you very much want us not to reach it, and I totally hear you, and you might be right. We might not actually. But the case is in front of the Court of Appeals. We are here for argument. I did ask you if you're familiar with what's going on in the district court, and I'm just curious if you could help me be comfortable that what's going on here is a legitimate exercise of PLRA authority.
Absolutely, Your Honor. So what the district court did in this case was very carefully review the evidence presented by both sides. I would add that he did not grant the full measure of relief that we sought, right? This is not a case in which it was a runaway victory for plaintiffs. He considered carefully the testimony of Dr. Vassallo, who is an expert in thermoregulation, and considered carefully sort of the full breadth of evidence presented by both sides and what is a very thoroughly reasoned, I believe, 78-page decision. It was his conclusion that the state's policies and actions demonstrated deliberate indifference to the very severe threat of heat, and that the policies that the state had in place were insufficient to address that threat. The specific remedies ordered were a decision based on what the expert testimony demonstrated was necessary to combat that threat. To the extent that there are concerns about the details of that decision, the court would, of course, have to first find that it does have jurisdiction to consider them. I haven't heard any argument presented that it does. And of course, the state will have an additional opportunity to seek review of any new preliminary injunction before it is moot. I would add that when the state sought review by the motions panel, I didn't see that particular argument in their papers, and it's not an issue that the motions panel was concerned with.
Do you think that the best way to do this is that we would just each summer get one of these preliminary injunctions, do some sort of interim relief, maybe a stay, partial stay, declare it moot at the end of the summer, and then come back again 9 months later? Is that? I don't mean it to be flip. I'm curious.
Understood, Your Honor.
Of how this is going to go.
And joining you and not intending to be in flip, absolutely the better way to do this would be to obtain permanent injunctive relief. That has been our aim throughout, right? We have not yet had the opportunity to do so. As a new heat season has approached, we have needed to seek a new preliminary injunction to cover the upcoming heat season. But I would add that if this court's concern is about repeated preliminary injunctions, it has the opportunity, as it said in Smith, to review that preliminary injunction before it comes moot. Neither Yates nor Smith did the court decide that it had jurisdiction after the 90-day expiration date. If what this court most wants to do is to review the merits, it should do so before the 90-day expiration date occurs.
Mm-hmm. Very good.
Nothing further. We would ask the court to dismiss without vacature. Thank you very much.
Thank you, counsel. Ms. Huettemann, I think you've got 5 minutes.
Thank you, Your Honor. Plaintiffs made a few points in argument here that I'd like to address, none of which provide a reason to depart from the conclusion required by Smith and Yates. I'll start briefly with one of the last things I heard my friend on the other side say, which is that they have not had the opportunity to seek permanent injunctive relief. They haven't given you any reason why they couldn't seek permanent injunctive relief, and as this court noted in Smith and Yates, it's the plaintiff's prerogative to so seek that permanent injunctive relief in order to avoid this 90-day expiration period and so to avoid the mootness of the appeal. And that leads into this second argument, this focus on the fact that the state sought unopposed extensions of their briefing deadlines pursuant to this court's rules. And I think Smith contemplated this idea. It made no difference, this pace of the appeal, what's going on in the appeals process, to the Smith court's ultimate conclusion. And in fact, as my friend noted, Smith actually contemplated the idea of an expedited appeal when discussing the mootness question. But that pace of the appeal and that ability to seek an expedited review made no difference in the vacatur analysis, and that's what we're talking about here. Defendants in Smith didn't seek expedited review, and yet that didn't weigh against them in the vacatur analysis, and it shouldn't so weigh against our defendants here. I think, Judge Oldham, you're right in asking what the defendants could have done here to prevent the mootness, and the answer is nothing. And that goes to my final point. This comes from the PLRA itself. The PLRA, as we all know, was intended to limit federal courts' discretion in prison litigation. And so it should come as no surprise to us that Congress included this mandated expiration period in Section 3626A2. And so this natural consequence of an appeal becoming moot when the expiration period runs out is simply a natural consequence of Congress's own decisions in writing the PLRA in the way that it did. The question of whether to vacate this injunction has already been answered unequivocally by this court in Smith and Yates, so this court must also vacate the underlying injunction order. Thank you, Your Honor.
Thank you, counsel. The case is submitted, and that concludes the arguments for this argument session. The court will stand in recess under the usual order.